Prosecution, the second pillar of the Philippine criminal justice system. When we say prosecution, it is the process of method whereby accusations are brought before a court of justice to determine the innocence or guilt of the accused. The prosecution will be the one who gathered necessary evidence with the help of the law enforcement pillar, and they will be the one to determine the existence of prima facie case, the file and prosecute the case in court. The role of the prosecutor is serving as the lawyer of the state government. In criminal cases, the prosecutor is automatically considered as the officer of the court. At the same time, the prosecutor is formally a member of the DOJ under the executive branch of the government and is thus independent from the judiciary. Ang prosecutor ay ang abogado ng people of the Philippines. We have prosecutorial discretion and selective prosecution. First, the prosecutor screens and evaluates the documents in order to decide whether to accept or refer the case of prosecution. Ang ginagawa sa prosecutor discretion ay ina-evaluate nila yung ating mga public prosecutor, yung mga dokumento whether sufficient na mag-file ng kaso. While selective prosecution, the responsibility of the prosecutor to evaluate the evidence that the police have gathered and decide whether it's sufficient to warrant the filing of changes against the violator. We have 4 legal factors considered by a prosecutor under selective prosecution. First, the legal strength of the case. Second, the suspect found guilty. And third, the willingness of the witness to testify. Fourth, the likelihood that the prosecutor can legally prove the defendant's guilty. Controversial expression of prosecutorial discretion. The decision to mitigate the defendants through reducing the charge, dropping multiple counts to leave a single charge. Recommending leniency to the court at sentencing parallel prison sentence. Duties of the prosecutor. Number 1, evaluate the police finding referred to them or other complaints filed directly with them by individual persons. Number 2, file corresponding information and proper court on the basis of their evaluation of the proofs at hand and prosecute and acknowledge offenders in court in the name of the people of the Philippines. Preliminary investigation. An inquiry or proceeding for the purpose of determining whether there is sufficient ground to engender a well-founded belief that a crime or cognizable by the RTC has been committed and that the respondent is probably guilty thereof should be held of trial. Officers authorized to conduct preliminary investigation. Provincial of city fiscals and their assistants, national and regional state prosecutors, such others, officers as many be authorized by law. Nole, I know Leia is a request made by the prosecutor, the judge for approval determined for their criminal prosecution against the suspect. Uses of nolle. Reduce case overload, reduce backlog, reduce delays in bringing defendants to trial. Arraignment, the local mechanism whereby an accused is brought before the court wherein the complaint or charge against his is read by the clerk of court in the presence of a lawyer and a prosecutor in which the accused is to announce his pileya. Pileya bargaining, the process of discussion of negotiation between the defense counsel and the prosecutor, named up reaching an agreement whereby the prosecutor uses this production to obtain from the judge Prima facie evidence. Establish a fact and units debuted explained by the evidence becomes conclusion and it is considered as it fully proved. Complaint is sworn written statement charging a person with an offense. Subscribed by the offended party any piece or the public officer charged with the enforcement of the law violated. Requisites of complaint. First, written statements under oath. Second, signed either letter A, offended party, letter B, any piece of officer or public officer charged with the enforcement of the law violated. Information is an accusation in writing charging a person with an offense prescribed by the prosecutor and filled with a court inquest investigation of a case performed by the fiscal assigned. Requisites of information. Number 1, written accusation. Number 2, a person is charged of an offense. Number 3, signed by the public prosecutors. And number 4, the information is filled with the court purpose of preliminary investigation. Number 1, to protect the innocent against hastily malicious and oppressive prosecution. Number 2, to spare him to trouble expensive and anxiety to a public trial. Number 3, to protect the state itself from useless and wasteful nights. And number 4, other officers authorized by law commonly conduct preliminary investigation on all election cases under the Omnibus Election Code 1987 mandates not only investigate but also to prosecute case of the violation of election law. PCGG, prosecution for the violation of RA 3019 anti-graft laws and RA 1317 unexplained well the Office of the Solicitor General can legally respondents government officially in preliminary investigation in the prosecutor's office on charge of violators of anti-graft law. Philippine criminal justice system. The second pillar, prosecution. Within the Philippine legal context, the prosecution plays a crucial role in the administration of criminal justice because it occupies a central and very important position between police and the court. Referred to either the process in the criminal justice system or a party in a criminal proceeding, it is the process of action whereby accusations are brought before a court of justice to determine the innocence or guilt. In criminal action, it is a proceeding instituted and carried on by due course of law before a competent tribunal of the purpose of determining the guilt or innocence of a person charged with a crime. The party in criminal proceeding who institute the criminal action is called the prosecution. The party against whom the criminal action was instituted. In all criminal prosecution, the real offended party is the people of the Philippines, for a crime is an outrage against and its vindication is in favor of the people in sovereign state. The prosecutor, the officer of the government whose function is the prosecution of criminal action for taking the nature of criminal actions. He is also referred to as public prosecutor, the fiscal. He also is quasi-judicial officer. What is the role of the prosecutor in criminal justice system? Officer of the court whose responsibility under the law is to carry out the administration of the criminal justice system through an adequate examination of the offense charge and to decide whether or not to prosecute the individual offender without sacrificing fairness and justice. He serves as direct contact between the government through the police agency and the court of justice and the criminal and the lawyers representing them. His series of contact is made from the moment that receives the case on the two criminal proceedings and until the final disposition of the case in the trial court. The role of the prosecutor in criminal justice system. In the criminal proceeding, the prosecutor has the basic responsibility of representing the government in the courts of justice. This responsibility is based on the principle that acts and omissions punishable by law, when committed, are always against the public interest and not only against the offended party. It is the reason that in criminal proceedings and the caption of the case is in the name of people of the criminal versus the offender. In the elements of the crime alleged to have been committed are present, it is in the prosecutor's task of bringing the offender to the court through criminal proceedings. He must see to it the innocent party is not unfairly and unjustly prosecuted. He must ensure that sufficient, strong, and convincing evidence exists in order to prove the guilt of the accused through the due process of the law. The defendant, through his lawyer, then protect his interest and sees it to it that prosecutor does not unjustly and unfairly prosecute the case. It is one of the 6 major functional offices and service of the Department of Justice. It assists the Secretary of Justice in the performance of power and function of the department relative to its role as the prosecution arm of the government, particularly in the investigation and prosecution of all criminal cases except those under exclusive jurisdiction of the Office of the Ombudsman. It was created by virtue of PD number 1275 entitled Recognizing the Prosecution Staff of the Department of Justice and the Office of the Provincial and Cities Fiscal Regionalizing the Prosecution Service. This law was enacted on April 11, 1978 under the general supervision and control of the Secretary of the Department of Justice. It was composed of the prosecution staff in the Office of the Secretary of Justice headed by Chief State Prosecutor, the Regional State Prosecution Office, and the Provincial and the City Prosecution Office. Its primary task is to investigate and prosecute all criminal offenses defined and penalized under revised penal code and under special laws. On April 8, 2001, Republic Act number 10071, otherwise known as the Prosecution Service Act of 2001, became a law. This law was enacted to strengthen and rationalize the National Prosecution Service. This law renamed the head of National Prosecution Service from Chief State Prosecutor to Prosecutor General. The Prosecutor General is appointed by the prosecution staff in the Office of Secretary of Justice and such number of regional prosecution office, Office of the Provincial Prosecutor, Office of the Prosecutor. The NPS shall be primarily responsible for the preliminary investigation and prosecution of all cases involving violations of penal code. Under the supervision of the Secretary of Justice in Section 3, Republic Act 10071, the prosecution staff has the following function: assist the Secretary of Justice in the exercise of his/her appellate jurisdiction, conduct the preliminary investigation and prosecution of criminal cases involving national security, those which task force have been created and criminal cases whose venues are transferred, avoid miscarriage of justice all when so directed by Secretary of Justice as public interest, may require act as counsel for the people of the Philippines in any case involving or arising from a criminal complaint investigated by any of its prosecutors and pending before any trial court investigate administrative charge against prosecutors, others prosecution officers, and the members of their support staff. Prepare legal opinions on queries involving violations of the revised penal code and the special penal laws, and monitor all criminal cases filed with the Office of the Prosecutor General. Maintain an updated record of the status of each case and adopt such system and procedures as will expedite the monitoring and disposition of cases. Section 5 RA 1107. The DOJ desires it mandate primarily from Executive Order 292, the Administrative Code of 1987 under EO 292. The DOJ is the government principal agency. As such, a DOJ serves as the government prosecution arm and administers the government criminal justice system by investigating crimes, prosecuting offenders, and overseeing the correctional system. The DOJ is headed by the Secretary of Justice. The Secretary of Justice is appointed by the President. The Office of the Secretary of Justice has 6 major functional offices and services, namely Office of the Prosecutor General of the Chief State Counsel, Technical Staff, Administrative Service, Financial Service, Planning and Management Service. Investigates the commission of crimes and prosecutes offenders through the National Bureau of Investigation or NBI and the National Prosecution Service or NPS, respectively. Likewise, the DOJ administers the probation and correction system of the country through the Bureau of Correction or BUCOR. The Board of Pardons and Parole BPP and the Parole and Probation Administration PPA, Bureau of Immigration BI or National Bureau of Investigation or NBI, Bureau of Correction, BUCOR, Parole and Probation Administration, Public Attorney's Office for Alternative Dispute Resolution Commission on the Settlement of Land Problems, Office of the Government, Corporate Counsel, Office of the Solicitor General, the Public Attorney's Office as recognized pursuant to RA 94, otherwise known as the Chief of Public Attorney. Its main objectives are to provide the indigent sector access to the counsel at the time of need and implement the constitutional guarantee of free access to courts, due process, and equal protection of the laws. Preliminary investigation is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. It is required to be conducted before the filing of the information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. The purpose of conducting preliminary investigation is to establish probable cause. Probable cause refers to the existence of such as facts and circumstances as would excite a belief in a reasonable mind acting on the facts within the knowledge of the prosecutor to inquire concerning the commission of crime and the connection of accused with it in order that he may be informed of the nature and the character of the crime charged against him. If there is probable cause for believing him guilty, that the state make the necessary step to bring him to trial, to preserve the evidence and keep witness within the control of the state, and to determine the amount of bail if the offense is bailable. Provincial or city prosecutors and their assistants, judge of the municipal circuit trial courts, national and regional state prosecutors, other office as may be authorized by law. A Tanod Bayan Special Prosecutor as authorized by the Ombudsman, COMELEC's authorized legal officer in connection with election offense. Special prosecutors appointed by the Secretary of Justice. Procedure For preliminary investigation, there must be complaint accompanied by the affidavit of the complaint and his witness as well as other supporting documents to establish probable cause. The investigating prosecutor shall either dismiss the case or issue a sub judice to the respondent within 10 days after filing of the complaint. Procedure for preliminary investigation. The respondent shall submit his counter affidavit and that of his witness within 10 days from receipt of the sub judice if the respondent cannot be subpoenaed, or if he failed to submit counter affidavit within the prescribed period. The investigating prosecutor shall resolve the complaint based on the evidence presented by the complaint. The investigating prosecutor may set hearing if there are facts or issues to be classified. The hearing shall be held within 10 days from the submission of the counter affidavit or from the expiration of the period submission, such as hearing shall be determined within 5 days. Procedure for preliminary investigation. Within 10 days after the investigation, the investigating prosecutor shall determine whether or not there is sufficient ground to hold the respondent up for trial. The termination of the hearing shall be the end of the investigation. If the investigating prosecutor finds cause to hold the respondents for trial, he shall prepare the resolution and information visual forward and record of the case. Provincial or city prosecutor or chief state prosecutor within 5 days from his resolution.